Good afternoon, everyone. This is the latest installment in the Penn State Center for Agricultural and Shale Laws series, which is an Understanding Ag Law series. And this one is called Understanding the Basics of Landowner Immunity Statutes. And I'm Brooke Dewar, the staff attorney here at the Penn State Ag Law Center, or Ag, I should say, the Penn State Center for Agricultural and Shale Law. And why don't we go to the next slide, Jackie? She's going to go ahead and advance our slides for us. Now, the center is a legal and academic research outlet for ag legal stakeholders in rural communities, and we provide much of our content through our website, which is at aglaw.psu.edu. Couldn't be simpler than that. Of the things that are on our website, one of the main things that people know us by is the Agricultural Law Weekly Review, which is a weekly newsletter of agricultural legal developments that we send out. We've been pretty good lately on making sure that we get it out for a Monday morning distribution there. So please sign up on our website. There is a drop-down menu in About the Center, I believe, is where you can subscribe to our weekly reviews. We also have a Shale Law Weekly Review, which deals with the latest developments in oil and gas law. We have some research products and research areas, one of which is a virtual resource rooms, where we have all sorts of materials on particular legal topics about oil and gas law or agricultural law. We also have a item on our website that are called issue trackers, which are the sort of the contemporaneous following of a legal development as it's developing, such as a lawsuit or a regulation, proposed regulations, let's say, or other ag law issues that sort of have an evolution, and we follow them as they go. So you can also follow them as they go forward. One of the other things that we have is a drop-down menu for watch or listen, which has audio and video content, including our podcasts. And we have a ag law podcast and a farmland energy legal podcast. And then we have videos of all sorts. Our webinars are pretty much all on here. We house them on a YouTube channel that's accessible through the watch or listen menu item on our website. There's also a events tab across the top where you can find out what webinars we have coming up, as well as you can go back and look at past events. And looking at those past events is a great way to go back and find the PowerPoints, for example, from events that we've already had or held. And then again, the subscribe to our newsletters, for example, is under the About the Center dropdown. Okay, next slide. Is that the right next slide? Yes, I guess it is. One more plug for things on our website, which is there is a tab for the Pennsylvania Agricultural Mediation Program, which we operate on behalf of USDA, but is wholly funded by USDA. And this program historically facilitated mediations between ag producers and USDA on USDA-related issues. And USDA pays for the mediators, so the parties do not pay for the mediators. The mediators provided essentially at USDA's cost. In recent years, the scope of issues that can be subject to the USDA-funded mediation program include many non-USDA issues: land and equipment leases, family farm transition issues, farmer-neighbor type disputes. Basically, we can also go to the Secretary of Agriculture and get approval for just about any, and that means the PA Secretary of Agriculture, for just about any topic to be handled through the Ag Mediation Program. So it's a great way, without cost to you, to mediate a dispute that you may have that arises out of your ag operation or your rural land holdings. All right, next slide. Today's topic is, this is part of the series called Understanding Ag Law, which is sponsored by the Pennsylvania Department of Agriculture's Agricultural Business Development Center, which was funded by the Pennsylvania Farm Bill. And It was established in 2019, along with the first Pennsylvania Farm Bill. And our mission in this is basically to provide sort of subject matter literacy and competency on some fundamental issues of agricultural law to attorneys and other types of business professionals and advisors who represent ag and rural clients, who might not otherwise specialize in ag law. And we try to get people a little more educated and provide some resources for people who want to know about some of these topics. And then we also are beginning, now that we've been doing this for about a year, this is our 13th one in the series, and we're beginning to start to do some more finer drill downs into some more specialized knowledge about some of these topics as we go forward. So look for that next year. We will be doing that. Okay, next slide. This gives you an idea of what some of the past topics have been in this series. Again, all of the webinars are on our website that we have completed to date. You can go on there and watch them, and all the PowerPoints and other associated materials are on there. In fact, for today's webinar, our PowerPoint is posted, correct, Jackie? I believe it is, as well as some other ancillary materials. In other words, some additional materials on the exact topic. There's some fact sheets in there. So take a look at that. We try to produce a little bit of companion materials each time with the webinars, not just the PowerPoint itself. Our next topic, the next slide, sorry. The next one will be on June 23rd, and we're going to have Understanding the Basics of the Farm Credit System. Doug Durkin, who's an attorney with Horizon Farm Credit, is going to be our presenter for that one. And as you notice, we're generally always on Fridays at noon. And then the next one after that is July 28th, and that will be Understanding the Basics of Pesticides. And the registration for the farm credit one is open now, so you can register. And then we will get a page up soon for the registration for the pesticide session. One last slide here, housekeeping issues. Webinars being recorded, of course, so be aware. You please use the Q&A feature for questions rather than the chat. It's a little easier to deal with that. We will have some surveys that come out during the course of the webinar. Those are really helpful for us to know what topics you might want to know about in the future, what to do, what to cover. So please fill those surveys out if you can. Helps also to know who's attending and who we might want to concentrate on more to get additional attendance. Of course, if you're attending this for CLE credits as a Pennsylvania licensed attorney, you'll need to click the link for the CLE form that will be posted in the chat. And Jackie, I believe that's posted already, right? Yes. Okay. So it's not yet. It will be. Just hang on and fill it out as soon as you can after the event, because we do have some time limitations on submitting those, and we'd like to get it done within a day or two. So please do fill that out today. It really helps us out. Now, the one thing about that CLE form is you have a code word that you need to pick out while attending here. And we're not going to tell you what it is now, because then that would blow the idea that you're supposed to be paying attention to get it. So we will be announcing the code word at a later time. Jackie will handle that herself. So listen for that, and then you put that on your CLE form, fill it out, and we send it in, and the credits appear on your transcript. Okay, last slide. All right, here's our topic for today, presented by Jackie Schweichler. Jackie is a staff attorney at the Ag Law Center, just like myself. She does a lot of different things for us, and really valuable to us in terms of helping us with sort of supervising a lot of or overseeing a lot of our student researchers, law students who work for us. And she's the primary author of our Shale Law Weekly Review, and she manages the Pennsylvania Agricultural Mediation Program all by herself, and that's quite a lot of work. With that being said, I'll let Jackie take it from here. Jackie, it's all yours.
All right. Well, thank you, Brooke. I really appreciate that. So I'm going to just jump right in. But before we dive into the liability statutes, I want to lay out the foundation of this topic for anyone who might be new to this concept of landowner immunity statutes. First and foremost, I want to acknowledge the endless list of risks that you might have on an agricultural facility or on your farm. And before I go much further, I do want to say that the first poll has popped up, so please complete that when you get a chance. So if we're looking at the slide here about risks, very easy, obvious things that most of us already think about, things like farm equipment, tractors, any kind of machinery can be dangerous to someone who's on your farm and not familiar with that type of equipment. Paths and walkways. You see the picture here, it's snowing and it's one of those wet snows where it makes everything very slippery, and that can be dangerous. If you have a petting zoo or if you have any animals on the farm that could come into contact with customers or even just, friends and family, there's always a risk of zoonotic diseases, animal tendencies, things like kicking or biting, just things to be aware of. And with all this potential for danger, farmers and landowners, they're expected to go above and beyond, right, to protect their on-farm customers. But, there's no such thing as a 100% safe farm, which is why we have these immunity statutes. So for the attorneys in the audience, here's a little refresher on duty of care. For everyone else, a little background on what duty of care is. Duty of care is the concept that a landowner owes different visitors to their property a different amount of attention and care, depending on that person's status. For example, a landowner could owe the lowest duty of care to a trespasser. For our non-attorneys, it might be surprising to know this, but yes, you do owe trespassers some care. You can't engage in activities that would cause a trespasser harm. For example, traps. You can't set a trap for a trespasser. So if you know that people are trespassing on your property, you do not have the right to set a trap intending to injure those trespassers. And if you do that, they can sue you even though they were the ones who were trespassing. So important to know. And the next type of status is licensee. A licensee would be a family member or a friend. A landowner is obligated to warn their friends if they have a loose porch step, or that's something that they could step on and trip or get hurt on. The status that's most relevant to our discussion today is the invitee. An invitee is someone who's on the property for a business purpose. With an invitee, the landowner has the duty to inspect the premises and fix or correct any possible dangers. So with my front porch step example, the landowner would have to warn of the danger, as guests are coming onto the property, and then they would need to fix that broken step as soon as reasonably possible. That's the highest level of the duty of care. Now, when it comes to landowner liability laws, our focus will be on torts and civil liability lawsuits. In general, a landowner will not be protected from criminal lawsuits under immunity laws. On the next two slides, I'll talk about which of these torts are likely to be covered by these statutes and which are unlikely to be covered. First, and most importantly, we're going to talk about negligence as it applies to torts. Negligence is the failure to act as a reasonable person would act under similar circumstances. That's the very general definition. For example, in the broken porch step example, a reasonable landowner would fix the step or put up a sign, especially if they expect to have customers or visitors onto their property, if they have an agritourism business. Most of the immunity statutes that we are going to talk about today, they are designed to prevent negligence lawsuits. And I know for any non-attorneys, this is a lot. So if you have any questions, definitely put them in the Q&A, or we can follow up with an email after the webinar. Now, most torts are not going to be covered under immunity statutes. These laws do not protect landowners who are accused of things like assault or battery, etc. However, nuisance is a type of intentional tort, and agricultural operators accused of nuisance might be protected by law. So a nuisance, by definition, is an activity that can be described as harmful or annoying. The legal definition says that it's the interference with a person's private use and enjoyment of their land. The activities of an agricultural operation might be considered a nuisance by the perspective of their neighbors at times. For example, an operation with beef cattle or swine might emit pretty strong odors, or an agritourism operation with hay rides for children, that might get pretty loud. As I mentioned, most of the laws that we'll talk about today prevent negligence lawsuits, but the right to farm law in Pennsylvania can offer some protection from nuisance lawsuits that are sent against farmers. Okay, last, we'll talk about strict liability. In strict liability cases, the injured party doesn't need to prove that there was negligence or an intent to cause harm. A person can be liable regardless of how careful they were during that activity. So on the slide here, we have the different types of strict liability: animals known to be harmful, abnormally dangerous activities, and then products liability, which can include design defects, manufacturing defects, and labeling issues. For our purposes, strict liability lawsuits are less likely to be covered by immunity statutes. So that said, animal injuries bring up a lot of questions because an immunity statute may protect against some injuries from animals so long as the injury is an inherent risk in the activity. The key language is when an animal is, quote, known to be harmful. That means that if the animal has already harmed someone, or if the owner knows that the animal is aggressive towards people, in that case, if that animal is known to be dangerous, it's likely to be a strict liability crime, and the landowner is a little less likely to be covered or protected by that immunity statute, if there's any chance of that at all. Now, to protect yourself from a civil lawsuit, you generally have 4 options: liability insurance, entity formation. You can have your guests sign notice of risk and waiver forms, or you have these state immunity or state liability legislation statutes. The first 3 things on the list we're not really going to talk about too much in this webinar. We have other webinars and presentations and materials on those topics. So if you are interested in learning more about that, send me an email. Okay, so these are the laws that we're focusing on today. So first, the Pennsylvania's Agritourism Activity Protection Act, the Equine Activity Immunity Act, the Recreational Use of Land and Water Act, and Right to Farm. Briefly at the end, we'll get to that. Just to make it a little bit clear to distinguish these, the main difference between these is the first 3 laws focus on liability relating to consumer injuries, negligence, that sort of thing, whereas Right to Farm focuses on preventing liability relating to nuisance. So that's sort of how I've divided these up when we talk about them today. All right, I'm going to take a little pause here and issue the CLE code word. So if you are an attorney hoping to get CLE credit for this webinar, please write down this code word either on a scrap piece of paper or put it directly into that CLE form that was posted in the chat. You don't have to complete the CLE form right now, just by the end of the day, but write down this code word somewhere. It's liability. So that's just the usual spelling of liability. It's right there on the screen. And I'll give it just another second here. All right, code word is liability. Please have that written down, and I'm moving on. So we're going to spend most of the time today talking about Pennsylvania's Agritourism Activity Protection Act, partly because it's fairly new and people have some questions about it still, and also because many of the basic principles in this law are actually reflected in the other immunity statutes, so it's a really helpful one to talk about and use as an example. Now, typically, an agritourism liability protection statute is going to limit the liability of an agritourism operator. This means that if someone is injured on an agritourism operator's property, the injured person generally cannot sue the operator for any injuries that they sustain from an inherent risk in the activity. So, as an example, I ask on this slide, what would be an inherent risk at an animal petting zoo? So I think most of us can assume that an animal might bite or kick or even knock you down. Even if it's a small goat, it could trip you and you could fall. Inherent risks are things that should be obvious to anyone in the business. So the act itself, on June 30th, 2021, HB 101 was signed into law as Pennsylvania's Agritourism Activity Protection Act. It's, I still consider it very new. So this new law grants an agritourism activity provider liability protection from civil liability for injury or damages sustained by a third-party participant in an agritourism activity. I will note that this does not apply to all agritourism activities. Specifically, Pennsylvania's act is different from every other state agritourism liability statute in a few significant ways. Unlike every other state, Pennsylvania specifically excludes liability protections for injuries that occur during weddings or concerts. So any attorneys who are new to Pennsylvania or new to this, working here in the state, just be warned that barn weddings are specifically not covered. So if you're used to working in a different state where they are covered, not here. In addition, Pennsylvania's act will not apply to injuries sustained during overnight stays or as a result of food or beverage service. Now, in order to receive liability protection, the operator has to meet these key elements of the statute. The first thing is they have to meet the definition of agritourism, Pennsylvania's definition, and then the farm has to qualify as a, quote, normal agricultural operation. We'll bring up the definition of that later. And then the operator must also have a written agreement that is signed by the participants, or they have to issue tickets. And then they also must have signage posted. Oops. Okay, so the first element that must be met in order for this liability protection to apply is that the injury must occur while the visitor is participating in an activity that meets the definition of agritourism in the law. So it's a little bit of a long definition, so I'll read it kind of quickly here. The definition is a farm-related tourism or farm-related entertainment activity that takes place on agricultural land and allows members of the general public, whether or not for a fee, to tour, explore, observe, learn about, participate, or be entertained by an aspect of agricultural production, harvesting, husbandry, or rural lifestyle that occurs on the farm. So as you can see, this is a pretty broad definition, and unlike some states, it does not highlight a specific activity to protect. In other words, this should be pretty much cover anything remotely considered agritourism. Some states will include very specific things, like I think New York includes wine and like Christmas tree farms and things like that. So this, I think, was probably deliberately broad. And the other thing I want to point out is that it does say whether or not for a fee. And that's a sticking point for some states when they're trying to pass one of these immunity statutes is, some groups will want to only pass the statute if, the farmer doesn't charge a fee, which of course, when it comes to agritourism would make the statute worthless, because how else are you going to make money? So the whether or not for a fee is really valuable, especially when it comes to most agritourism operations. Okay, the second requirement, or element number 2, is that the agritourism activity must occur on land that is used for a so-called normal agricultural operation. And the definition of normal agricultural operation, that's actually defined under Pennsylvania's right to farm. So we have that listed here on the slide. And that says that the activities, practices, equipment, and procedures that farmers adopt, use, or engage in the production and preparation for market of poultry, livestock, and their products, and in the production, harvesting, and preparation for market, or use of agricultural, agronomic, horticultural, silviculture, and aquacultural crops and commodities. The other very long definition is just a very broad understanding of what you would expect an agricultural operation to look like. The specifics, the details where you might get caught up, is that it requires the farm to encompass at least 10 acres, or if it's less than 10 acres, it must generate an annual income of $10,000 or more. So think very broad. This is a very broad statute, very broad definition. Whatever you're growing, whatever you're farming is probably qualified, probably falls under this definition. So, and you're going to fit it as long as you have that 10 acres or you generate that income of $10,000 or more from your agricultural activity. Now, the third element in Pennsylvania statute is that a visitor must sign an agreement to waive liability before they engage in the agritourism activity. Very generally, I'm not going to read this one. The ticket says, I understand that the agritourism provider is not liable for any injury to a participant resulting from an agritourism activity. I accept all risks. Please note that at point number 1, there's no liability protection for the agritourism provider if they act in a grossly negligent manner, on purpose, or criminally. So again, this is not protecting you from criminal activities. And I do apologize for anyone who might be trying to read this tiny print on here. There is a lot of there's a lot of language on this slide. I could have spread this out over multiple slides, but I wanted to make it very clear that the written agreement that has to be signed, it must contain all of this information. So just make sure that if you're preparing this written agreement for someone else, or if you're preparing it for yourself, it's all together. It's written on at least 10 point and in bold font. So this is the language that you need for your waiver. Now, if you just thought to yourself, getting people to sign a waiver might be kind of difficult depending on, how people come onto your property, getting people to, flow through the front doors, or maybe they're accessing your property from a few different locations. Pennsylvania does have an alternative to this. They allow operators to print that same language, the agreement and warning language, but you can print it onto a ticket. Two things to remember here. First, the ticket must include that exact language, and guests will have to use that ticket to enter the activities. So operators are still going to need to figure out how to filter their guests to some sort of entrance in a way that they can check to make sure that everyone has that ticket with that agreement and warning language. So you can use a waiver, a signed waiver, or a ticket that they purchase and then use for entry. Okay, the fourth requirement or fourth element of the statute refers to signage. And every agritourism statute that I have seen requires some sort of signage posted. So this is very, very normal. Every state has this that has an agritourism statute. So the required warning signs have to be posted on the property at conspicuous locations, and they have to be 3 feet by 2 feet in size. And they need to be placed in a way that they're, easy to observe and see by the participants of your activity. So, and then the language, of course, on the sign warns participants to read the agreement that was provided by the operator on the ticket or the waiver. And the sign explains to participants that the agritourism operator will not be liable for injuries should the participant be hurt while they are on the farm. So very typical language. And I think you can actually buy these signs right from Farm Bureau if you're not interested in making your own. The last thing I want to say about Pennsylvania's farm statute or agritourism statute is that the law states that a parent or guardian must sign the acknowledgement agreement on behalf of a minor or care dependent person. But as a note to this, generally children do not have the legal capacity to sign liability waivers. And so a waiver signed by a child might be voidable. It's going to be up to Pennsylvania courts to decide whether this law will have the intended effect when it comes to claims of injuries by minors. Right now it's an unsettled legal issue, and we're going to have to wait and see how the court deals with this and just see how it works out. That said, a parent's signed waiver would waive the parent's claim for compensation relating to their child. And then on this slide here, I have some resources for you in case you're interested in reading the language of the statute for yourself. I've also included a link to Pennsylvania Farm Bureau's resources on this statute. I think they have a link to the signs there if you want to purchase one. And yeah, and then if you need access to these sites, they are again on our website on a couple of different pages. So if you're looking for these links, they're on the PowerPoint on the website, which the link to that's also been posted in the chat. All right, so moving on to Pennsylvania's Equine Activity Immunity Act. So the Equine Activity Immunity Act covers individuals, groups, clubs, or business entities that sponsor, organize, conduct, or provide facilities for an equine activity. Now, obviously, this law is only going to provide protection for agritourism activities involving horses, but for people in that business, it is a very powerful law and very helpful for those individuals. Similar to the agritourism immunity statutes that we just looked at, the Equine Activity Immunity Act provides liability protection so long as the participant assumes the risk and that the operator posts signs to warn the public. So we have these elements here that we saw earlier. We have the assumption of risk, signage, And then, of course, they actually make a note of it in this statute that it does not provide immunity from claims presented by children. So that is something to note here. The Act says that directly. And then I also put in a small note at the bottom here. One does not assume the risk for faulty equipment. We'll talk about that a little bit more if we have time later. So the signage requirements, very similar to the Agritourism Act. In order to use this defense against liability, they have to meet all the requirements we talked about, and they have to have these 3-foot by 2-foot signs. They have to be posted conspicuously. They need to be in 2 different locations, and the language has to say, you assume the risk of equine activities pursuant to Pennsylvania law. So it's a little shorter, a little less words to include on their signs, a little easier to do. But, signage required at least 2 locations. Why not have 3 if you can afford it? All right, so the specifics. So if we're talking about what other activities are covered by the Act, we've got equine training, teaching. So if you're teaching classes about horses on your farm, riding, instruction, shows, fairs, parades, competitions, performances. I'm just reading the slide here. Clinics, seminars, demonstrations, boarding, breeding. So really anything you can think of with horses or other equines, it's probably going to be covered under the Act. Now, some of these things might be a little bit more difficult. For example, if you're, going to different locations, you can't really post signs everywhere that you travel to. So some of the shows or fairs might be a little bit difficult, but, have signs that you can bring to travel with you, I guess. They have a few different options, but if you're not an attorney, talk to your attorney about it. If you are an attorney, look into different options where you can make this work for you when you travel. Okay, there's an interesting case that I wanted to talk about with the Equine Activity Immunity Act, where I had that note about how it does not apply to faulty equipment. This was a fairly recent case, 2016. So the participant or the facility was denied the use of the Equine Activity Immunity Act. So what happened is Melendez, he signed a waiver assuming the risk of all activities of horseback riding. Okay, so that's an element of the Act. Good. There were signs posted at the facility, and they were the correct signs, the right size, the right language, everything. While Melendez was horseback riding, the stirrup that he was using broke. The broken stirrup caused Melendez to fall, fractured ribs, suffered others terrible injuries, and then they brought this lawsuit. So Melendez argued that the Equine Activity Immunity Act did not apply because he was not aware that the stirrup could be defective. And then the court agreed. So this was not a case, and they said, quote, this was not a case where the risk was so obvious that the knowledge could be inferred. So the idea is you have the expectation of certain injuries when you participate in activity, but what the court's saying here is you don't have an expectation that a stirrup is going to break on you. So there are some nuances, some specifics to this law. It's not, it will not protect you against everything. And that's why I wanted to bring up this case. So, it's important to check equipment and make sure that those sort of things are working because it's not necessarily covered under this Act. All right, moving on, we are going to the Recreational Use of Land and Water Act, which everyone I know just calls it RULWA, so I'm probably just going to call it RULWA the whole time. But if I say RULWA, I mean the Recreational Use of Land and Water Act. All right, so for Pennsylvania landowners who don't meet the definition of a normal agricultural operation, RULWA might be your best bet to get some liability protection. So it's been in effect since 1966. It applies to landowners who allow the public to enter their land for recreational use. And I do have a link to the actual statute at the bottom of this slide. And again, the slides are posted on our website. So what does it actually do? RULWA limits liabilities for landowners who qualify. And it does this by lowering the duty of care owed by the landowner. So under this law, a landowner does not need to inspect their property or to warn people who were on their property. The duty of care here is the same level of care owed to a trespasser. So the difference is instead of owing the highest level of care, it would actually be the lowest level of care as long as you qualify for RULWA. And the lowest level of care is, of course, you can't set traps, you can't do anything that would be considered deliberate or malicious that could cause injury to people on your property. Now, a few years ago, RULWA received a big update that expanded its application to a wider range of landowners. In addition, the payment language was changed. So the original statute did not apply to landowners who accepted payments from people who entered their property. So in other words, if you got money from people who are going on your property to kayak or hike or walk around and look at the flowers, if you got any sort of payment from them, RULWA did not apply. You were not protected. Now, with the 2018 change, landowners are actually allowed to accept some forms of payment. The change also expanded the list of activities that qualify as a recreational purpose. So we're going to talk about the recreational purpose definition first, and then go to the payment specifics. So this is very, very broad. Generally, recreational purpose under the statute means any activity undertaken or viewed for exercise, sport, education, recreation, relaxation, or pleasure. And then there's a whole long list, hunting, fishing, swimming, boating, picnicking, hiking, snowmobiling. I'm just reading a few of these off this slide. Enjoying historical, archaeological, scenic, or scientific sites. I mean, really anything you can think of. There's a huge list here. So just inviting people onto your property. It's very, very broad. So there's a good chance that, depending on what you're having people do, it might be covered by RULWA, which is really interesting. So it includes a lot of things. But again, if you want to read through this, slides are available on the website. Now, when it comes to charging people who come onto your property, there's some specifics for how you're allowed to accept those payments for those fees when you charge them. So the fees, you're allowed to accept payment and use that payment to conserve or maintain the land, to pay taxes or real property, or to pay for liability insurance on the property. So whatever income you're getting for these people who are hiking or canoeing on your land, you need to make sure that that money is going into, doing these things, conserving the land, paying taxes, or paying for the liability insurance. So it's really specific, but if you want the RULWA protection and you don't want to have to pay, just crazy amounts of money for liability insurance, but you want to offer this access to your property to the public, this is just pay attention to how you can accept payments, and you just make sure that you fit the language here. And it is a little complicated. So I would definitely, if you're a landowner, either ask an attorney to make sure that you're doing it the right way, or talk to an accountant or someone, but it's pretty specific. And just a quick reminder, I think this language is in all of these statutes. You don't have to warn of dangerous conditions under RULWA, but you can't be malicious. So, there's no liability protection for willful or malicious failure to guard or warn against a dangerous condition, use, structure, or activity. So in other words, if you've got a bridge that's broken and has gaping holes in it, you know about it, and you're like, I don't care. Well, you might not be protected under RULWA. So if you know about it, and if it doesn't take a lot of effort on your part, if you put up a sign, that's you're meeting your duty of care to warn, perhaps, in that situation. So you can't be malicious. You can't deliberately do anything or deliberately ignore anything that might be a danger to people on your property. Okay. All right, we are moving to right to farm. And again, right to farm is a little different because instead of negligence lawsuits against the landowner, this law is talking about nuisance lawsuits that are going to be brought against the landowner. Now, right to farm statutes have been enacted in all 50 states. Their focus, again, is on limiting nuisance lawsuits against farms. And the point is to, stop these conflicts. Let's all move on. So the key here is that right to farm, the point is to try to avoid unreasonably interfering with your neighbor's property. So we have to weigh the benefits of the activity against any harm caused by the activity. So if a farmer sets up an agritourism activity that primarily operates at night, and there's loud music and bright lights everywhere, and it's located near a residential area, depending on how they go about it, right to farm might not protect that farmer, or maybe it will. The determination of reasonableness, that's going to depend on a few different factors. So under right to farm, municipalities are required to exclude normal agricultural operations from the definition of public nuisance. Specifically, these laws limit nuisance actions against normal agricultural operations. So you might remember we just went over the definition of normal agricultural operation a few slides ago. So I'm not going to include it again here, but just very quickly, in order to meet the definition, the farm has to, do all those general agricultural activities, and the farm in question has to be at least 10 acres or produce an annual gross income of at least $10,000. Now, if the agricultural operation has been expanded or altered in some way, right to farm can still be used as a defense if the operation was expanded or altered at least a year ago. So it's been changed for at least 1 year, or the expansion or alteration was addressed in a nutrient management plan. So there's a little bit of wiggle room there. Right to farm also limits the ability of municipalities to restrict direct commercial sales of agricultural products. So with right to farm, farmers who produce at least 50% of the commodity sold are allowed to have direct commercial sales on their land. So this is really valuable for agritourism operations. If you are an agritourism operator and you want to, engage with right to farm and try to use that to prevent nuisance sales, this is really valuable. So if you're producing and selling for 50% of your agricultural commodities, you're allowed to do that under right to farm. So that's a really valuable tool that you can use. It's sort of the why not both question. You can try to get if you're an agritourism operation, you can try to get the immunity from the Agritourism Act. If you have horses, maybe you've got a horse operation as well, try to get the immunity from the Equine Facility Act, and you can also try to get the immunity from right to farm. So you can see how all of these different statutes work together, potentially overlap in some places. So it's really good to know a little bit about how all of them work and potentially use that for your own purposes. Okay, so right to farm, it's not a perfect catch-all safety measure. It doesn't apply if your activity is deemed to have an adverse effect on health and safety. It also won't apply if your operation is prohibited by zoning or if it violates laws or regulations. So I think those are all the things listed there. Oh yeah, and that's also, I think on the slide here I have, if your agricultural operation pollutes water or causes flooding. So there's a whole list of things that they don't protect you, things that you probably already know off the top of your head. So if you're causing a nuisance that's more than just a casual nuisance, like a smell or a little bit of sound, you might not be covered by right to farm. So read all the rules, check all the insight there. And actually we went a little bit faster than I expected. So I'm going to talk a little bit about the mediation program and how that applies to these statutes. So one of the things with these statutes is that if you are, if someone has threatened to sue you, and even if you think that one of these statutes might protect you, you have other options. You don't have to go to court and immediately fight this. If you are in Pennsylvania, one of your options is that you can request mediation through Pennsylvania's Agricultural Mediation Program. And as Brooke mentioned at the very beginning, the mediation program was originally created by USDA to resolve USDA type issues. So if you have an issue with USDA about your farm loan, or you're working with FSA on a farm loan and there's some sort of problem with the payments or just the way that the loan is structured, and you're getting an adverse decision from them and you're confused and frustrated, you can request mediation for that. If you have some sort of conservation program, anything with USDA, you can generally request mediation. Now, with the program expansion for mediation, we can also do non-USDA issues. So any issues between farmers and landowners, or farmers and other farmers, even some on-farm disputes, we can mediate. We can do things like leasing issues, anything relating to pesticides, organics, things like that. And how this would work in this situation is, let's say that you have, if you're an attorney watching this and you have a farmer client who comes up to you and says, my neighbor is threatening to sue. They're saying that, let's do the right to farm example. they're saying that, my farm is really, they hate the odors, it's too loud, they're trying to sue me. Yeah, maybe right to farm would protect that farmer. But the farmer tells you, well, I don't want to pay a lot of money. I don't want to go to court at all. First of all, why did you come to me, an attorney, and make this request? So you have this problem, and I get a lot of calls from farmers who don't want to have to go to court, but they want the problem to just go away. And that's not the way that the world works. But this is potentially a solution for that in some very specific situations. So if you have someone who has an issue and they don't want to pay you, their attorney, to deal with it, and you don't want to deal with them because they're being really difficult about this issue, you can recommend the mediation program. This is, again, it's a free program right now with our current budget. And so you can give them the information on the program. They can reach out to me. We'll talk about the issue. And yeah, so the first step is getting the first individual to agree to mediate the program. And then the second step is getting the other person. And that's usually a little bit more difficult. So if farmer A, who is concerned about being sued and they want to mediate, I get them to agree. We talk about their schedule. We get some dates in mind. And then I go to farmer 2 or landowner, landowner number 2, and I say, hey, we'd like to try to mediate this out of court, save you money, save them money, save time, effort, energy. And, then we can all stay friends versus fighting something out in court that might take years and is definitely going to ruin whatever neighborly friendship you might have had in the past. Once we get the both sides to agree to mediate, what we do with our program is we hire a third-party mediator. That third-party mediator comes in and they sit down with those two and they come up with some sort of agreement. Usually we like to have the agreement written down, but this is not an agreement that, carries the weight of law, and the mediator isn't an arbitrator, right? The mediator isn't creating, a solution for the parties. They're not saying, this is what you have to do. This is the end goal. This is what we're going to happen. The two landowners or the two farmers are going to come up with their own solutions to the problem. The mediator is going to help them discuss it. And then one of the beautiful things about this program is that it's done through the center. So the Center for Agricultural and Shale Law, where we work. So if there are legal questions, or if they want to know more about, how easements work or how certain other things work, what they can do is they can, the mediator can reach out to us, or, we can jump into the mediation and answer some of those questions. So it's a great way of getting both mediation and answer to some of these really complicated legal issues that a lot of farmers struggle with and they don't necessarily understand because there's not a lot of opportunities to do that.
All right.
All right, that's all I have.
Okay, great. All right, we're right at 1 o'clock. So thank you, everyone, for attending our latest installment in the Understanding Ag Law series. And again, our next one will be up on June 23rd. I hope I have that date right. And it will be Understanding the Farm Credit System with Doug Durkin, who is an attorney with Horizon. So hope everybody can make it for that one. And always open to hearing your suggestions for other topics that you would like to hear about. Liability insurance, for example, if that's something you'd like to hear about, let us know, because that's something that I think is definitely follows nicely on the heels of this one. All right, everybody, have a good day.